like we still got a few folks that are connecting to audio, so we'll give them a little bit longer. Okay, well, I think we'll go ahead and get started. Joel, we still got a connection here. Can you hear me?
Yes, we do.
All right, great. Well, hey,
Yeah.
good evening, everyone. My name is Ken Coffin. I'm the president of the Beartooth Front Community Forum, and tonight we're bringing you another webinar in our series of webinars. And tonight we're going to talk about who owns the water, a basic conversation in Montana water regs. So, but before we get to that, I just wanted to take a few minutes to talk about who we are. Beartooth Front Community Forum has been around since 1992. And as you can see on the screen, we're basically a grassroots, nonpartisan organization who strives to promote thoughtful, constructive dialogue around regional and community issues through public education and engagement. A few of the outgrowths of the forums, and we typically do that. So in pre-COVID days, we would have one or two in-person forums where we would be addressing some topic relevant to the Beartooth face, or Beartooth Front rather. And so in the past, some of those efforts have led to the creation of the Boys and Girls Club in Red Lodge, the Red Lodge Master Plan, as well as bear-proof garbage containers in Red Lodge. So it has a long history, and it's a great organization to be a part of. If anybody's interested, please feel free to contact me or put a note in the chat, and we can send you information. We'd love to have a few more members as part of our steering committee. So as I said, our focus within Beartooth Front Community Forum for the last year, about a year ago is when we started this. It's what we call our Outlook 2030 webinar series. And we're really interested in kind of talking about the impacts of growth along the Beartooth face, and how it can potentially affect communities along there. We've had, I think, 4 webinars to date that have addressed topics that we feel are relevant to increase growth in the area. That being tax-supported superior infrastructure, managing impacts of growth, housing, that's in an acute place here in our community. And then our most recent webinar had to do with community hydrology. So kind of led up to what we're talking about today. Water is, a big issue for a lot of folks. So we do have a few more webinars planned that we feel are relevant to this, to growth, community growth, and that being wildfire being one of them. So we're working on getting Mark Finney, who works for the Forest Service out of the Missoula Fire Science Lab, to talk about wildfire in the 21st century. And they're also working to get Chris Drimmel from the Greater Yellowstone Coalition to come and talk about climate change. So we don't have those dates set, but I'm hoping to have that worked out here in the next month or so. All right, just a few ground rules for the event. If folks would just please make sure you're on mute as we work through this, that would be great. We're going to have about a 30-minute presentation. Somebody have a question? Hey, could folks put your computers on mute? Thank you. So we're going to have about a 30-minute presentation, and then we'll end a little bit of a small, hopefully maybe a small panel discussion between a couple of folks, and then we'll open it up for questions. If you have questions, please put them in the chat. Once Robin joins us, she'll be monitoring those and make sure those get in the queue. We are recording this event, and so if you go to our website at beartooth.org, beartoothfront.org, you can see not only this webinar but the previous 4 webinars that we've done. So, and if you have any technical issues, there's the link to Zoom support. So I am going to stop talking and turn this over to Joel and let him moderate the conversation henceforth. Take it away, Joel.
Okay, thanks, Ken. If you could keep an
organization that does this kind of stuff.
Water rights.
No.
If you could monitor people in the waiting list in the waiting room and admit them, I think just hang on a moment. I think Robin just jumped on.
Oh, good.
And we'll make Robin a co-host. There we are. Okay. Well, it's my pleasure to introduce our speaker tonight, Mark Elison. Mark grew up in Missoula, received a bachelor's degree in geology from University of Montana, and he's got a master's and a PhD in geology from Northwestern University. After a short stint in the oil industry, Mark spent about 17 years teaching math and science at Billings Central High. And then in 2013, Mark joined the DNRC as a hydrologist and currently manages the Billings Regional Water Resources Office. And Mark's going to give us a short presentation, kind of Montana Water Rights 101. And after that, we're going to have a short discussion session, and we'll field questions from the audience. Again, please post those questions to the chat, and Robin will manage that. And with that, I'm going to turn it over to Mark, and we'll learn something about water rights.
Well, I hope we will. As Joel indicated, my name is Mark Elison. I'm a manager here in the Billings office for the DNRC, and this is going to be pretty brief and kind of an overview. There's a lot to Montana water law, and I'm just going to pretty much skim the surface. So if there are specific things that you're interested in, we'll try to get them at the end, or maybe I'll get some of them as we go along. The DNRC has a mission statement, which is to promote, coordinate the beneficial use, conservation, protection, and development of Montana's water resources. So we are tasked with the use of water in the state of Montana. So the very first question that was asked was, who owns Montana's water? And it all comes down to the 1972 Constitution, which declared that the water is the property of the state. So in essence, the members of the state, the citizens of the state, own all of the water in the state. And all of that water is for the beneficial use of the people. However, what we have in Montana is a water right, which gives you a license to use that water. So if you're going to use the water in the state of Montana, that's all owned by the people of the state, you need a license, a water right, and that gives you the legal permission to use that water. And one of the most important things about water rights in Montana is that we are under a prior appropriations doctrine. In the East Coast, they have what they call a riparian doctrine, and if water exists or a stream goes through your property, you can use it. In Montana, it is who put the water to beneficial use first. So every water right, every license to use water has a date on it, its priority date. And the older the priority date, the higher the value, if you will, of that water right. You have the earliest permission. First in time is first in right. We'll get to what that means in a little bit. But a water right is extremely valuable, that permission to use the state's water, because it is a property right. It is monitored under property law. It's protected by the Constitution. You can buy and sell them. There's a process that is required. Water rights are generally appurtenant to a piece of property, and they need to be severed from that property and then applied to a new piece of property someplace else, or a new use someplace else. And all of that requires changes in the permit, but they do have value and can be bought and sold. And you can't lose them without due process. All right, so there has to be a process by which a water right is taken away from you. So this was all set up in the Constitution. And then a little bit later, July 1, 1973, the legislature passed the Montana Water Use Act, and that created the Department of Natural Resources and Conservation. Our fundamental job, as defined in the Montana Water Use Act, is to be the record keeper of all water rights in the state of Montana. So there are basically two kinds of water rights now based on this Montana Water Use Act. There are those that were in use prior to July 1, 1973, and all of those that have come into existence after July 1, 1973. So we have adjudication for those earlier water rights and a permit system for new water rights. So for what do you need a water right? The fundamental comment is to withdraw, divert, or impound. So MCA, Montana Code Annotated, defines appropriate. So we talk about water rights as appropriations, is to divert, impound, or withdraw a quantity of water for a beneficial use. So if you're building a home and you need to dewater the ground to put in your foundation, you don't need a water right. There is no beneficial use. You haven't diverted, impound, or withdrawn the water. And a person may not appropriate water, divert, impound, or withdraw without a permit or an authorization for a change. So fundamentally, that's how you can tell whether or not a water right is needed for any use. So let's go to the two different kinds of water rights. There is adjudication. So these are all the water rights that existed prior to July 1, 1973. And they were of a variety of sorts. People, some are called use rights. People just started using the water. Some were actually filed at county courthouses. Sometimes people would put up a notice nailed to a tree or a post that said, I am going to use this source for this amount of water. So it was a pretty random system. And the Montana Water Use Act established the court system, the Montana Water Court, to examine those claims and to determine the value and the nature of all of those water rights that existed prior to 1973. So what eventually happened was that anyone who had one of these water rights was required to file it by January 1, 1982. So if you had been using water since the 1800s, you still had to submit a form saying, I have used this water, And this is how, when I started, where I use it, what it's for, and that all goes to the water court. So the water court is hopefully going to issue final decrees. Almost all of the basins in Montana have preliminary decrees, and we are moving toward final decrees on all of the basins in Montana. We're crossing our fingers for 2025. That got put back a little bit because when the original filing period was initiated, domestic use for household or stock uses from wells, springs, or directly from a stream or river were exempt from the filing requirement. So you could file on them, but you were not required to. Well, a couple of years ago, the legislature said, well, we need records of these. And so they opened another filing period. We call it the House Bill 110 claims. And so all of those claims for domestic and stock uses direct from sources or from springs or wells then had to be examined and added to the list of pre-1973 water rights. But with any luck, all of the basins in Montana will have a decree for their pre-1973 water rights in the next few years. You can get a water right at present. So we have a system for obtaining water rights for any use that you would like to use the water for. That would be after July 1, 1973. For now, we call them beneficial water use permits. They are separated into groundwater and surface water. And they're required for all uses, all surface water and groundwater exceeding 35 gallons a minute or 10 acre feet. There is an exception for small groundwater that I'll talk about in a minute. You must obtain a permit prior to construction and implementation of any appropriation, any attempt to withdraw, divert, or impound water. And there are several criteria that we will, that the department would look at in any new permit, but fundamentally you must prove that the water is physically and legally available. The water is there and nobody else has already appropriated it, and that your appropriation will not adversely affect anybody with an existing water right. Well, the adverse effect provision became very, very interesting after Montana Trout Unlimited versus the DNRC in 2006, based on groundwater depletions of the Smith River. And now we should have known this all along, but we are now required to recognize that there is a connection between surface water and groundwater. So if you want to make a groundwater appropriation, that groundwater appropriation will presumably deplete a surface water source. And so we have to not only look at the physical and legal availability of the groundwater, but also the surface water that would be depleted. And so someone who is using the surface water for irrigation or stock use, for example, could be adversely affected by a groundwater proposal because of the connection between the surface water and the groundwater. So the exceptions to permits are basically come in two forms. One is what we just call 602. It's a small groundwater development. So you put in a well or a developed spring, and as long as it does not exceed 35 gallons per minute or 10 acre feet, then you simply create the system, develop the spring, drill the well, put it to use, and then send the form in to us. It's a notice that you have completed the groundwater development. So it requires no criteria analysis, it's basically exempt from all of those requirements. The other one is a stockwater pit. And this is, I mean, particularly in eastern Montana, every coulee has a dam on it because that's how you get and preserve stock water over the summer months. Non-perennial sources, it can't be more than 15 acre feet, and it has to serve a parcel of land that it's at least 40 acre feet. And once again, this is one that you put in, you create the reservoir, and then you file with the department that you have completed a stock water reservoir. So these are exceptions to the permits because they are determined that they will not have adverse effect on other people because of their size and construction. The one thing that everybody wants to know about, and this comes up with the notice of completion of groundwater development, Form 602, and that is that there is a concept which is combined appropriation. If I'm going to, maybe I need 100 acre feet of water, and so I'm going to put in 10 wells that are all exempt from permitting requirements. Well, that happened early on, and so there had to be some restriction on how these were used. I know this slide has a lot of words, and it's because the concept of combined appropriation has changed dramatically and is complicated. The department has had a series of definitions of combined appropriation, but recently lost a court case and was thrown back to the original, which is here. If the appropriation is from the same source and in the department's judgment could have been accomplished by a single appropriation, it's considered a combined appropriation, and it is limited to the 10 acre feet. Well, nobody's going to like very much in the department's judgment, so there has to be some explanation of what that means. And so the way the policies are currently used is if any two wells or springs are physically manifold, they're a combined appropriation. If there are any lots that are less than 20 acres in size, prior to 2014, are allowed to have multiple groundwater certificates that are not combined if they are not physically manifold. After that date, any lots that are less than 20 acres are limited to a single 602, and lots that are greater can have multiple wells, springs, pits, as long as they're a quarter of a mile, 1,320 feet away from one another. This is probably going to be changed again within the next couple of legislatures. I know that there are bills being proposed to try and better define what the use of a exemption is, the exception from permitting is for. The legislative intent early on was for areas where domestic use and stock use was far from any municipal water supply system, any flowing stream, and it was to provide for domestic and stock use primarily in those areas. The use has expanded dramatically, and the current policies regarding combined appropriation are not terribly workable, but this is the way it rests at present. We can go into that in more detail if you like later on. Any water right that has been issued by the department, whether it's a statement of claim for a pre-1973 water right or a permit for one after that date, you can change. As situations and conditions change, it often becomes necessary to change your water right. You are required to change it if you change the point of diversion, the place where the water is taken from a source, the place where it's used, the purpose, for example, going from irrigation to industrial or something like that, or if you add storage to the system. And so that's another process that is administered by the DNRC. The most important part of the change authorization is that you must prove what the historic use of the water was and that the change will not increase that use of water, because you will retain the same priority date after the change. So you can't add to an early water right through the change process. How do you know if you have a water right? Well, there's a few, these are some tools that are really helpful. One is Montana Cadastral. This is run by the Department of Revenue, and it allows you to find a geocode and a legal land description for any parcel of land. So if you had a parcel or had purchased a parcel, you could go to the Montana Cadastral website, find the geocode for that property and a legal land description. Armed with that information, you could go to the DNRC's water right query system and put in the geocode, the legal land description, any of those things, and find out if there was a water right registered for that piece of property. Then also the Montana Bureau of Mines and Geology maintains a groundwater information center that shows wells and well logs and where wells have been drilled. And the Water Rights Bureau, our website, is where you could find forms, general information, anything like that. So these would be places that would be helpful. And you're going to find yourself in the water right query system from the DNRC. And there's a couple of pitfalls to that. The very best way to search is to have a geocode, because the geocodes, because the water right is appurtenant to the land and the geocode specifically defines a piece of land, if there are any water rights appurtenant to that land, they will show up by using the geocode. Not every water right is geocoded, but that's the single best way. You can look under owners' names. You can look under previous owners' names. It's possible if you have the water right number, it pops right up. But so searching is, it depends on what kind of information you have, but the query system will allow you to search by owner, by geocode, by a legal land description, by a source. So, and if none of that works, you call your regional office, your regional DNRC office, and they will help you determine whether or not one exists. If you go to the Montana Bureau of Mines and Geology and you find a well log for a piece of property, that's not a water right. And this is one of the more common misconceptions we get, is that, well, we had the well log was registered, so we're good. But the well driller sends the well log to the Montana Bureau of Mines and Geology, but the water user is responsible for filing with the department. So there's a well, but it doesn't necessarily have a water right unless it's been filed with the DNRC. And so a well log on the Montana Bureau of Mines and Geology website does not necessarily mean that there is a water right on the DNRC website. So because the water rights are pertinent to the land, ownership updates need to occur. If you were to buy a piece of property and there were water rights associated with that property, you would want to update them into your name. And so that is something now that is a high priority within the department. The legislature has determined that updates will occur within 30 days of the time they're filed so that ownerships don't languish, because in the past we've had cases where the property has changed hands multiple times, but the water rights are still in the original owner's name because they were never changed. The water right always goes with the land unless you specifically sever it from the land in the deed. So that can be done. So one can write a deed that sells a property of land, but keeps the water right. And then that water right could be sold to somebody else or changed to be used in a different place. The other thing that often happens is a water right was used, say, for example, on irrigation for a 20-acre parcel, and now that parcel has been split up into, 4 or 5 acre parcels. Well, then each one of those individuals owns a piece of that water right, and it can be split so that they have an individual water right. One of the questions that Joel threw my way when he asked me to do this was whether or not there were basin closures. The entire upper Missouri basin is closed. In our area, you'll see there are a couple. The Rock Creek drainage basin is closed, and there is a controlled groundwater area near Absaroka called the Horse Creek Controlled Groundwater Area. And what does that mean? A closure can mean almost anything. It depends on the rules that were written when the area was closed. So for example, the Rock Creek Basin closure, Rock Creek and all of its tributaries are closed to appropriations of surface water between June 1st and September 30th. So you can still get a water right in the Rock Creek Basin. There's only the closure between June 1st and September 30th to surface water. That does have ramifications for groundwater developments, though, because the two are connected. So, but each closure is subject to the specific rules that closed that basin. For example, the Horse Creek Controlled Groundwater Area, it has limitations on how much water you can use from a well, and specific requirements that you cease all outdoor water use if the standard precipitation index, a measure of precipitation, falls below a certain value. So there's just limitations on your well use in that specific area. Each closure will have its own set of rules. The other interesting question was ditches, and the DNRC has no authority over ditches. We have some authority over the head gates at the sources for these ditches, but ditches are owned by ditch companies in some cases. In some cases, they are not. They're owned by all of the people that use them. There might be, 20 people that use an individual ditch, and it's not really owned by any of them. And so they have to work together to repair and maintain that ditch, or it falls apart. And so ditches are a very interesting and separate piece of this puzzle. But we don't administer them at all. So if you have a ditch company that has shares, we won't even have a list of who those shareholders are. A lot of the ditch companies have bylaws, which are perhaps recorded with the Secretary of State, but certainly not with the DNRC. And so the last two little comments down at the bottom are kind of critical. The ditch owner is responsible for repair and maintenance of the ditch. A property owner cannot encroach upon or otherwise impair an easement for ditch use. And in property law, it becomes interesting because these easements for ditch use are prescriptive easements that have developed over decades or hundreds of years. And so they may not be written, and it may not be written in an easement of a property you buy that a ditch goes across. It's interesting because the questions I was given, who owns the ditch? And sometimes it's hard to tell who owns the ditch. If it's a ditch company, at least you have somebody you can contact. The ditch owners do have some rights to enter onto private property. There's a specific statute that says that the owner of a ditch can enter onto private property for the purpose of repair and maintenance of the ditch. And it's kind of interesting because the urban legends, the folklore that goes with that, you talk to people and they'll say, well, yeah, you have 2 oxen. That's the width you have on either side of the ditch, or you have 20 feet on either side of the ditch, or any number of things that have been handed down. In fact, state law does not prescribe that. You have the right to enter on for repair and maintenance of your ditch. If you're doing it in a destructive manner, then probably the landowner has recourse to the courts, but there is nothing specific about that. You can't move the ditch if you don't like where it's located. You can't use the water in the ditch unless you have a water right that uses that ditch. And you cannot build a pond on the ditch. All of those things would require permits and water rights in order to be that way. No, ditches are sacrosanct. And if you live down around Red Lodge and you're up on the west bench, you can see the entire area is crisscrossed by ditches. So no, ditches are not administered by the DNRC, but they are a source of constant conflict, and most of law that revolves around ditches is case law from legal actions that have been taken. One last question I got asked was, does Montana have minimum in-stream flow requirements to protect aquatic values, recreation, and such? It does not as a state. In 1978, when we began to reserve water for various purposes, irrigation from conservation districts, the FWP, the Fish, Wildlife, and Parks, reserved water for fisheries. And so there are some sources that have a Fish, Wildlife, and Parks reservation on them with a 1978 priority date. So the Clark's Fork or the Yellowstone ranges up to 3,477 cubic feet per second in June, and as low as 117 in October cubic feet per second. So the Clark Fork has one. There is a reservation on Rock Creek, which goes from about 25 cubic feet per second up to 418 cubic feet per second based on the season. So there are in-stream flow reservations that are held by the Department of Fish, Wildlife, and Parks, but the state does not have a minimum in-stream flow requirement. There's a few questions on here that all come to the same thing, and that is who has priority if there's a problem? The Montana water law is based entirely upon prior appropriation. The oldest water right has priority. And it doesn't matter if the oldest water right is for irrigation and a younger one is for domestic use or municipal use. There is no priority of uses. And there is no required sharing. So if the oldest water right gets all of their water before the next oldest right gets any. So the way the system is set up, the prior appropriation doctrine, the priority date on that water right is that trumps everything. So the oldest water right gets all of their water. They can make call on any junior water right until their entire water right is satisfied, and there is no priority of uses. So really quick and dirty, I've sort of covered a really brief dip across the top of Montana water law, and hopefully I left some time that we can maybe dive into a few of those issues a little more. Thank you.
Thank you, Mark. That was great. Much appreciated. I guess before turning it over to the questions that have been posed on the chat, put you on the spot. What do you think the biggest water-related issues, areas like the Beartooth Front, are going to face in the next 10 to 20 years?
The transition of water use from irrigation, particularly flood irrigation, to a lot more domestic uses, smaller parcels of land that want a fish pond or an aesthetic pond as opposed to using the water for irrigation. So that development, that change in the use of water is going to drive a lot of what goes on in that area.
Sounds like job security for you.
That has
and a bunch of others.
Never been an issue.
No. Thank you. I'm going to, Robin, if you want to take charge here.
Yeah, sure. So just as a reminder to everybody, if you've got questions, go ahead and stick them in the chat. And then, you know, if we have questions about your question, we might ask you to unmute and elaborate. So we've got one from Janet asking, why don't ditch owners take responsibility for maintaining the ditch? Other than taking legal action against a ditch company or ditch owners, what recourse does a property owner have?
You say other than, and you gave the only recourse that the owner has. I cannot answer the question of why they do not maintain their ditches, because it seems to me like it would be a pretty vital thing for them to be maintaining their ditches to get their water right. If the ditch is leaking or blowing out or causing damage on somebody else's property, then the recourse is through the district court. And there, when you say other than going to court, what is your recourse? Well, you can talk to your neighbors, but there is no law in Montana requiring neighbors to be friendly, and in many cases they're not. So you essentially end up talking to them, trying to get them to see that they're causing you property damage. And if that doesn't work, the only recourse is to court.
No, thank you. And we've got another one on ditches from Corey. Correct me if I'm wrong. A ditch flows seasonally and a creek flows year round.
Yes, the ditches typically have periods of diversion, periods when they are allowed to divert water that range from spring to late fall for irrigation purposes. Some ditches are also run year round for stock water, and some ditches collect water from groundwater over the course of the year, so they may have water flowing in them year round. So it would not, and some streams are ephemeral or non-perennial. So you couldn't make it would not be clear to say that a ditch is a stream that flows periodically, and a river or creek is one that flows year round. That typically a ditch is designed to carry water that is appropriated by someone and has a period of diversion that is not year round, typically.
Gotcha. And Jim asks, does the FWP water right trump some water rights, or can earlier rights continue despite FWP efforts?
The FWP in-stream flow reservations are priority date 1978. And so if you earlier water rights can continue to use their water regardless of what the amount of water in the stream is. Fish, Wildlife, and Parks can only make call on water rights junior to their 1978 priority date. And it's interesting because up and down the Yellowstone River, it changes whether or not the city, the conservation district, or the Fish, Wildlife, and Parks has the senior priority date by minutes, because when the court issued its order, it would give a priority date of 12/14, 12/18, and 12/20, and they vary. So, but no, they are subject to the prior appropriations doctrine, and they have 1978 priority dates.
Great. Yeah, thank you. Ken Coffin asks, can a water rights holder lease or allow others to use their water right?
No. There was a temporary lease statute that allowed you to lease your water right temporarily for some other use. But it was not widely used, and it has been rescinded. So no, not legally. The water right is for a specific purpose in a specific location. And so your license to use the state's water is a license to use this amount of water at this location. It doesn't give you a right to lease it. It's not, no, that would be in violation of the Montana Water Use Act.
Yeah, thank you. And John Clayton asks, what is the role and value of a watershed council? Does Rocket Creek have one? And if it doesn't, does it need one?
Only the local people would be able to decide whether they needed one. There are a couple of huge values. One of the things is that the prior appropriations doctrine is rigid. It does not foresee or plan for sharing shortages. It doesn't plan for priorities on any uses. And a watershed council can encourage and work with landowners and holders of very senior water rights to encourage and drought planning, shared shortages, minimum flows for recreation fish, those kinds of things. It can work with the water right holders to soften the prior appropriations doctrine so that the system maintains better health. So yes, I think they're incredibly valuable, but they are only as valuable as the cooperation they can build within the watershed.
Right, thank you. Yeah, and I know we do have a local group that has been looking at these issues, so I think that's why John asked. We've got a question from Jeff Benedetto. If a water right can be severed from a land parcel, can that right be transferred to a corporation, municipality, or other entity for use off-site or bought and sold in a speculative market?
Yes. For example, in Bozeman, they're in a closed basin. They have dramatic residential development. Anytime they're going to use water, they have to mitigate for the depletions to the surface water source. And the solution is typically to buy a water right, an unused water right, retire it, and use that for the mitigation water. And so that does happen. It can be severed from the land and then sold. However, in order to use it someplace else, you would have to change the water right. The water right is from a source to a location for a purpose. So now you're going to take this water right, sever it. You want to take it someplace else. You have to change it to a new point of diversion for a new purpose in a new location. And that requires a change authorization from the department. So it only has value in terms of where you could use it, where you could move it. You can't, buy a water right on Rock Creek and sell it to somebody in Bozeman. That doesn't make any sense. So you have to be able to justify the movement without adverse effect and go through the change process. And so the value of a water right is going to be in part, is there a market that can use it in that location beneficially? And so, people say, what is it worth? And it's almost impossible to put a value on that because it will depend on what you want to do and where you want to do it.
Right, and I know of an example in Big Sky, the Big Sky Community Housing Trust. They were awarded water rights from the Water Authority to build affordable workforce housing, and they used it as sort of a bargaining chip to get some partnerships with private developers to make that project happen. So it ended up being incredibly valuable and made a 50-unit development feasible.
Well, you could imagine a case where somebody had water rights that were irrigation water rights that flowed through an area that is now subdivided. And so now you have this water that's pertinent to that land, and you could use it you could send it further down the ditch, which would be valuable. You could use it locally for lawn and garden irrigation. You could do an aquifer recharge. Any of those things would be potential benefits that you could sell that water for. But, it's going to be local. The use is going to be local if you're going to try and resell a water right.
We've got a couple more minutes. If there any more questions, we can go ahead and stick them in the chat. I'm not seeing any more right now. All right, then I'll go ahead and give it back over to Joel to close us out.
Thanks, Robin. Having been involved in doing water right change applications in the past, it's a very complicated process. I don't know if it's gotten any easier over the years, but even though you've had X amount of water flowing down the ditch, your right is actually only that amount which you beneficially used. And you have to prove what your beneficial use was. That is plant uptake. And so it's a very, very complicated process, and it sounds easy.
Can I put in a little plug for that? Because thanks to in part to the governor's red tape initiative, the Water Rights Bureau, the Water Division of the Department of Natural Resources and Conservation is undergoing a complete, transparent, stakeholder-driven look at all of our processes to try and streamline those, to make them more understandable, less complicated. We are still in the process of taking input, listening to people to determine what is the best course of action that allows us to continue to protect existing water rights. But yes, it's an extremely complicated process, and we are currently looking at what could be done to alleviate some of that complexity.
Okay, and I think just to, I guess, make a point. I mean, I've talked to a lot of people that were concerned. There was a section of Rock Creek that went dry this past summer, and I think you made it quite clear that even though the fish were the first users, they don't have the first beneficial. They don't have the first water rights. So there's really nothing without a watershed council type of group that can keep that water in the stream.
That would be the greatest benefit for having a group like that to work with. I mean, even the irrigators will understand that a dry creek is not beneficial to anybody, and when water is short, it's better for everybody in the community if that shortage is shared. But the watershed groups need to work with those people to create plans to make that happen, and that's where they can be really beneficial.
Well, great. Well, we're pretty much on time. We've got a couple minutes, but not seeing any more questions come up. I want to thank you for doing a great presentation of a complicated subject.
Just touch the surface, but we are available.
All right. Well, thank you very much. And thank you everybody that joined us and listened in. And we look forward to being able to do in-person forums in the future, but I think our next forums are going to be very interesting. And I'll just ask Ken if he has any closing comments, or if we want to just cut it off here.
No more comments. Thank you, Mark. That was excellent presentation. Thank you.
Well, thank you for inviting me. We love to get out and see if we can't educate people. So thanks for the invitation.
All right. Okay. Take care, everyone. Have a good evening.
Night.